Welcome to the C's Group's training for the HIPAA privacy and security rules. During the course of this training session, we will be learning about the HIPAA privacy and security rules. We will learn which patient information or identifiers are considered protected health information under the HIPAA privacy rule and how to recognize situations when PHI may be potentially mishandled. As employees of the C's Group, we will learn about practical ways to protect our patients' PHI. Lastly, we will discuss the consequences of improper handling of PHI or other confidential health information. Let's get started. The Health Information Portability and Accountability Act, or HIPAA, actually became law in 1996. By 2003, the government issued regulations known as the HIPAA Privacy Rule to tell healthcare providers and other entities how patients' protected health information must be handled to protect patient privacy. The HIPAA Security Rule regulations followed in April 2005 and set standards for how electronic PHI was to be treated at all stages of its creation, transmission, and storage. Both the HIPAA Privacy and Security Rule were in place, but not often enforced, for several years prior to the passing of the Health Information Technology for Economic and Clinical Health Act, or HITECH. HITECH became law in 2009. And regulations for enforcement of HITECH were issued in 2013. Since September of 2013, under the provisions of HITECH, enforcement of the HIPAA privacy and security rules has grown exponentially. In order to understand our responsibilities under these laws and regulations, it is important to master the content of this training module. We will first examine the HIPAA privacy rule with an overview of the law and the individual program components. Next, we will discuss the HIPAA security rule and how it affects how we create, transmit, and store electronic PHI. The following is an overview of the HIPAA privacy rule. Understanding of the privacy rule is important to any healthcare worker's job. First, let's discuss who or what is covered by the HIPAA privacy rule. All C's Group entities are subject to the HIPAA privacy rule due to the nature of what we do. Our individual healthcare professionals, group physician practices, and ambulatory surgery centers all submit bills electronically to Medicare. That activity makes them covered entities under the HIPAA privacy rule. C's management also functions as a business associate to our independently contracted physicians, as C's management submits bills electronically to Medicare on behalf of those contracted physicians. There are two types of entities or organization types that are subject to the HIPAA privacy rule. The first are covered entities, or those organizations that submit electronic transactions to Medicare for their own work. Covered entities may also be a health plan with 50 or more members, as well as a healthcare clearinghouse, or companies that submit bills in bulk to Medicare for payment. In addition to covered entities, HIPAA also applies to business associates. Business associates are entities that perform a function on behalf of a covered entity, and as part of that function, the business associate uses PHI created, stored, or transmitted by the covered entity. Business associates can be many types of individuals or companies, including collection agencies, attorneys, outside auditors, or even mailing services. Now that we understand the difference between a covered entity and a business associate, let's discuss the sensitive data that each of those entities must handle and protect. Protected health information, or PHI, is individually identifiable health information that can be used to identify a single person. That PHI concerns the individual's physical or mental health, the care the patient received for their health, and any patient information related to that care. PHI is the information a covered entity creates when it is acting as a healthcare provider for an individual. PHI may be kept in many forms: oral PHI, paper, electronic PHI, video PHI, or even photos of PHI. We encounter PHI in its many forms every day in our jobs at the C's Group. We may see PHI printed on a fax or discuss a patient's case or account verbally. We also see and use electronic PHI in our electronic medical records, whether that PHI is at rest in our internal systems or in motion as it is transmitted to Medicare and other payers. Regardless of the location or form of the PHI, it is imperative that all C's Group employees protect the privacy and security of PHI in all its forms at all times. So what specifically are we talking about when we use the term PHI? The privacy rule defines PHI as any information that falls into 18 different categories as shown above. These categories may be as simple as the patient's first and last name or the facial image of the patient shown in a photo or video, to the more complicated pieces of PHI that include patient-specific dates, like a date of birth or a date of service, or even a patient's unique IP address. De-identified medical information is not considered PHI when all unique pieces of information that could be used to identify a single patient are removed. Research studies will often look at diagnosis-specific data, but since the patient's name, address, age, and other specific identifiers are not included in the research data, and the patient is unable to be identified, this data would be considered de-identified PHI. Any single piece of PHI or combination of multiple pieces of PHI that may be used to identify an individual patient are protected by the HIPAA privacy and security rule. PHI that is involved in an unauthorized release, which could be a misdirected fax, mail sent to the wrong address, or even gossip to someone not involved in the patient's care, is said to have been breached. For example, say you tell a friend about a female who came in for a blepharoplasty and who happens to live just around the corner at 2749 Skyline Drive in Chattanooga. Someone who knows the person who lives at that address overheard your conversation and is now able to identify the person who received the blepharoplasty. This situation is called a HIPAA breach and is a violation of the HIPAA privacy rule. What types of activities can result in a HIPAA breach? Typically, actions that fall into one of the three listed categories. Unauthorized disclosure outside the covered entity. This means sharing the patient's PHI with an outside person or entity who is not entitled to hear or have the patient's PHI, or sending the electronic PHI to a business associate with whom we have no written business associate agreement. Unauthorized use can also occur within the covered entity. If someone is sharing PHI with another team member when that team member has no need to know or hear about that PHI, that is considered an internal unauthorized use. Next, HIPAA breaches may also occur due to unauthorized access within the covered entity. For instance, if you have stepped away from your computer but failed to lock the computer, someone can then access the EMR under your login credential and see PHI for a patient that he or she did not need to see. Another example includes anyone who logs into the EMR to view PHI for a patient in whose care he or she is not participating. The access is done out of curiosity or even concern for a family member. This is still a prohibited access since there was no need for the employee to log in to view that patient's PHI. So what makes access authorized? It's very simple. If the access to the PHI is required due to the team member's job duties, that is an authorized access. One may also access the patient's PHI with his or her written authorization. For example, it might be that the patient calls in to get a reminder of his or her surgery date or preoperative instructions. In that case, the patient is directing the access and the access then becomes part of the team member's job role. Either access is then acceptable. Unauthorized access is any access that is not required by one's job duties, that is not undertaken at the direction or request of the patient, or in some cases is not access that is required due to other required reporting reasons. If you are just checking on a relative or looking at the PHI of a VIP patient or even just browsing patient data when your job does not require it, those situations are all examples of unauthorized access and as such are subject to disciplinary action up to and including termination of employment. Let's now discuss how unauthorized access or inappropriate sharing of PHI may lead to a breach of privacy as defined under the HIPAA rules. The 2013 final omnibus rule on HIPAA and high-tech gave us the first federal definition of privacy breach. That definition is simply the unauthorized acquisition, access, use, or disclosure of unsecured PHI, which compromises the security or privacy of the information. There are 3 exceptions to this definition. One such example is the unintentional acquisition of PHI. This might happen when a tech opens the wrong chart. She makes this error in good faith and does not further disseminate the information. This situation would fall under the unintentional acquisition exception to the breach definition. The same is true for the inadvertent disclosure of PHI from one person authorized to access PHI at a covered entity to another person authorized to see PHI at that same covered entity. For example, a nurse might hand off lab results for Betty A. Smith to Dr. Brown, but Dr. Brown really needed to see Betty R. Smith's lab results. This situation is an inadvertent disclosure and is an exception to the breach rule. Finally, unauthorized disclosures happen when PHI is disclosed to a person not authorized to access that PHI, but the person is not reasonably able to retain the information. For instance, if a nurse gave a patient just discharged from the ER the wrong discharge instructions, but the patient notices the mistake and swiftly returns the instructions given in error, that unauthorized disclosure would not be considered a breach because it would not be reasonable to believe the patient would be able to retain the information given to him or her in error. HIPAA breaches can happen in a variety of ways. The most common cause of HIPAA breaches recently has been the theft, loss, or improper disposal of paper or devices that contain PHI. As more and more PHI is kept on networks or even in the cloud, hacking is also becoming a common method of gaining unauthorized access to PHI. Lastly, verbal and written communication of PHI to individuals who have no need to know about a patient's PHI still continues to be a problem. How do we lower our chances of being involved in a HIPAA breach? All team members must remember to never leave paper containing PHI out on their desks or workstations. Medical carts, PCs, and laptops containing or displaying PHI should be kept in secured areas and locked when unattended. Any mobile devices, such as mobile phones or tablets, that may be used to access or view PHI should have a screen lock and access code that is known only to the user, so that those who have no need to view the PHI cannot gain access to it. If you are a SEAS Group team member who knows or suspects a HIPAA breach of privacy has occurred, you have a duty to report that incident to the compliance officer. Reports may be made anonymously, and no retaliation can or will be taken against a team member who reports a suspected HIPAA breach. Once the report of a suspected breach is made to the compliance officer must investigate the matter to determine if a HIPAA breach has in fact occurred. If a breach occurred, the compliance officer must then notify the patient whose PHI was involved with the breach within 60 days of determination that a breach occurred. In addition to notifying the patient, The compliance officer must also notify the Department of Health and Human Services and the Office of Civil Rights of any breaches that occurred in a given calendar year. For example, all breaches that occurred during the calendar year 2018 must be reported to the DHHS and OCR by March 31st of the following year. In addition to the notices that must occur for breaches involving only a single patient or a few patients, should C's group have a breach that affects 500 or more patients at the same time, C's group would then be required to self-report to the DHHS immediately, as well as post a public announcement of the breach on its websites. Lastly, C's group would also be required to report the breach through prominent media channels that serve the geographic area where the patients affected by the breach live. HIPAA breaches are not trivial. They cause quite a large administrative burden to all covered entities. Even small HIPAA breaches cost an average of $200 in administrative and investigative time. That does not include reputational harm the C's group may suffer in the communities we serve. Now that we understand what a HIPAA breach of privacy is, let's discuss what may happen as a result of HIPAA privacy breaches. Every C's group team member should understand that after the passage of HITECH in 2009, the federal government has increased the enforcement toolbox when HIPAA breaches are found. Individuals or covered entities found to have been involved in HIPAA breaches may now be found civilly and criminally responsible for breaches of patients' privacy. HITECH made it possible for the federal government to prosecute individuals or entities for HIPAA breaches when those breaches occur purposefully. Criminal penalties are set at a $50,000 fine plus 1 year in prison for every single count of knowingly obtaining false information in violation of the law. If HIPAA breaches are undertaken under false pretenses, such as a person or organization posing as someone they aren't, those penalties go up to $100,000 per occurrence, plus 5 years in prison per count. Lastly, if someone is found to have obtained PHI with an intent to sell it or use it for malicious harm to the patient, the fine is again increased to $250,000 per count, plus 10 years in prison. Civil penalties for HIPAA breaches are much more common and occur in a graduated fashion, typically when a covered entity has been found to be in violation of the HIPAA law and then fails to take remedial action to cure its previous violations. The first level of civil penalty is for providers or covered entities who know or should have known their actions were a violation of the statute. Those persons may receive anywhere from $100 fine to a $50,000 fine per violation, up to a maximum of $1.5 million in a single year in fines. In these instances, the covered entity has a chance to correct its behavior in 30 days, and in most instances, the Office of Civil Rights will waive or reduce penalties. Recurrent infractions by the same covered entity, however, will result in less leniency from the federal government. Covered entities that fail to correct their HIPAA infractions within 30 days due to what the government deems as willful neglect face a penalty of at least $50,000 per violation, up to a maximum of $1.5 million per type of violation per year, and those penalties for willful neglect cannot be reduced by the Office of Civil Rights at all. We hear a lot about HIPAA violations involving hospitals, but physician practices are not immune from governmental enforcement. Above are 3 recent examples of HIPAA violations involving physician practices. The fines range from a low of $100,000 up to a $750,000 fine, plus a costly and comprehensive corrective action plan the entity had to enter into to appease the federal government. Most people are surprised to learn that physician practices, not hospitals, are the most common type of covered entity required to take corrective action by the Office of Civil Rights following a HIPAA complaint to OCR. Because of their small size and relatively limited resources, physician practices typically have less robust compliance and privacy programs, making them much more vulnerable to federal enforcement than their counterparts like hospitals and nursing homes. In addition to the civil and criminal penalties now in place under HITECH, other remedies for HIPAA infractions were also created. States' attorneys general may now bring a lawsuit against covered entities on behalf of patients in their jurisdiction who have been affected by a HIPAA violation. If found liable under this state prosecution, the covered entity must pay $25,000 per violation, plus the costs and fees of the lawsuit. Congress also ordered the Department of Health and Human Services to create regulations under HITECH that would allow individuals who have been harmed by HIPAA violations to recover a portion of the civil monetary penalties levied against the covered entity. HITECH has been in place for almost 10 years now, and we are still waiting on those regulations. However, remember that although we have not seen those regulations come to fruition yet, we are still likely to do so unless HITECH is repealed. Covered entities have also been ordered to ensure employees who engaged in HIPAA violations are sanctioned. Thus, disciplinary action for HIPAA infractions is not optional. It is required. Make sure you understand the SEAS Group's HIPAA sanctions policy. Covered entities must also file an annual report with the DHHS disclosing any breaches that occurred during the previous calendar year. Should a breach involve 500 or more patients in the same service area, the covered entity must immediately self-report to the DHHS and make public notice through their website and local media to affect patients about the breach. Keep in mind that the Office of Civil Rights is now the federal agency responsible for HIPAA enforcement. OCR also undertakes HIPAA privacy and HIPAA security audits of covered entities and business associates to complement its enforcement activities. OCR audits have become a major tool in levying penalties against covered entities, resulting in major fines payable to the federal government. So far, we have talked about the definition of PHI and the many forms in which it may exist. We have talked about the specific patient identifiers that become PHI when used in the delivery of healthcare or the payment for that healthcare. We have discussed an overview of the HIPAA privacy and security rule and how those rules were strengthened by HITECH in 2009. We've also discussed how an unauthorized access of PHI can occur, resulting in the need to send a breach notification to the patient affected. Lastly, all SEAS Group team members have been reminded of their responsibility to report suspected HIPAA breaches. Now that we have a general understanding of the HIPAA privacy and security rules, let's dive into the specific individual rights HIPAA confers to our patients. Each patient has certain rights that are guaranteed by HIPAA. Those rights include receiving a copy of our Notice of Privacy Practices, so each patient understands how his or her PHI will be used. Patients may also request restrictions on how their PHI is used and require confidential communication of their PHI. Should a patient attempt to restrict the disclosure of PHI to his or her health plan, which SEAS Group requires in order to process payment, SEAS Group may then legally refuse to abide by that restriction request unless the patient pays in full for the service out of pocket at the same time the service is rendered. Patients also have a right to request a copy of their health record. If desired by the patient, SEAS Group must be able to produce an electronic copy of the patient's health record. The patient may request a correction or an amendment to their PHI. Patients also have the right to request and receive an accounting of disclosure, which is a list showing when and with whom their PHI has been shared. Lastly, patients have a right to file a complaint with any SEAS Group entity as well as with the Office of Civil Rights if the patient feels their HIPAA rights have been denied or their PHI is not being protected. The Notice of Privacy Practices, or NPP, must be prominently posted in areas where patients are likely to see it, including on our websites. NPP set out the rules for how SEAS Group will use the patient's PHI. Patients have the right to request restrictions on the way their PHI is used. Covered entities may generally decline requests if the request would cause undue burden on the covered entity. However, if the covered entity agrees to the restriction, it must follow that restriction for each encounter with the patient's PHI unless there is an emergency or the restriction cannot be followed due to other laws. Covered entities may terminate restriction agreements so that they don't apply to future patient interactions, but those restrictions would still cover past transactions when they were in effect. Think very carefully before agreeing to restrictions for PHI use and always consult your compliance or privacy officer. Covered entities will likely agree to not submit a patient's PHI to an insurer or health plan if the patient requests this restriction and is able to pay in full out of pocket for the services rendered. This is the least burdensome of the restrictions, but SEAS Group should only agree to this restriction when payment in full is at hand. Never ask patients if they want a restriction on PHI usage. Only respond when asked, and always tell the patient you will need to confer with your supervisor and the privacy officer. Patients may request that communication from SEAS Group occur through alternative means or even to alternative locations. Reasonable efforts should be made to accommodate those requests. Patients or their representatives do have the right to inspect or obtain a copy of their PHI that is residing in a designated record set. The designated record set includes any documents used to make decisions about the healthcare or payment of the patient, but does not include EMR bulletin boards, complaint letters, or responses to other extraneous writings. When requests to access PHI are received, they must be responded to within 30 days. PHI should be produced in the format requested by the patient. SEAS Group is allowed to charge reasonable fees for actual cost of labor for creating the copies of the PHI. Medical records reproduction fees are also governed by state statute. If you have questions about a request or the fees involved with producing a copy of PHI, please contact the compliance officer. Patients may sometimes disagree with the contents of their medical records or notice an error has been made in the information recorded in the medical record. When that happens, that patient may request an amendment to his or her medical record. The amendment request must be made in writing and submitted to the compliance officer. This request will be acted upon within 60 days. If the request is approved, the medical record will be amended accordingly. If the request is denied, the patient must be notified of the reason for the denial. The patient still has the right to ask that his or her original amendment request become a part of his or her official medical record. All requests for amendments should be directed to the compliance officer. Patients have a right to know when their PHI has been released to other entities, as well as the name of those entities. Thus, patients can request an accounting of disclosure, which is simply a list of all the entities who have received a copy of the patient's PHI, when that PHI was sent to the outside entities, and which specific pieces of each PHI were sent to the outside entity. Remember, if we are doing business with business associates who may also be disclosing PHI to parties outside the business associate structure, the business associate should also be supplying information about those releases to the SEAS Group so that information may be included in the accounting of disclosures log we must maintain for each of our patients. Direct requests for accounting of disclosures should be directed to the compliance officer. Now that we understand how a patient can direct how his or her PHI is used, let's talk about how we as SEAS Group team members may appropriately use or disclose PHI. Note that PHI cannot be disclosed without a patient's authorization unless certain exceptions exist. The first exception is known as the TPO exception, which means that PHI may be used or disclosed in the course of treatment, when pursuing payment for the treatment, or when engaged in activities known as healthcare operations, like disclosing PHI to the state or federal government for quality monitoring, or to an attorney representing SEAS in a professional liability case. PHI may be disclosed to family members or others close to the patient when payment arrangements are being made if the following circumstances exist. The patient has not objected to that disclosure. Limited PHI is only disclosed under appropriate circumstances, and the PHI disclosed is only limited to the scope of that person's involvement. For example, one child of the patient might be financially responsible for the patient while the other child handles the patient's medical needs. If a bill were under review, we wouldn't discuss clinical needs with a child with financial responsibility. We would only discuss payment obligations and arrangements. PHI may be disclosed for certain public safety concerns to governmental entities, TB or Ebola notifications, for example. For most disclosures, we must have a written authorization that is signed by the patient or his or her representative. What is the TPO exception? This is the principle under which we do the majority of our work, and when we use PHI for these reasons, we don't have to have a specific authorization from the patient to do so. We can share information as needed in order to treat a patient, arrange for payment for that treatment, or to engage in other healthcare operations. Keep in mind that the minimum necessary principle applies here. Use only the minimum amount of PHI needed to accomplish your purpose or job duty. Do note that psychotherapy notes are the one exception to the TPO exception. Psychotherapy notes cannot be disclosed, not even to the patient, without the treating physician's authorization. This is to ensure the safety of the patient and those around him or her. The treatment portion of the TPO exception covers communication of PHI between providers in a group, between a provider and a consultant in another group, or when referring a patient outside the group to a third party. The payment portion of the TPO exception includes all activities undertaken to obtain payment for the treatment rendered to the patient, including communications with insurance companies, collection companies, and lawyers in a collection proceeding. The healthcare operations portion of the TPO exception includes all other types of administrative, financial, legal, or quality improvement activities covered entities must undertake to fulfill their core business. When thinking about the circumstances for revealing PHI to a family member or other person involved in the patient's care, keep these rules in mind. If the patient is present and does not object after being asked, then you may discuss PHI in front of that family member or friend. It is also reasonable to infer that one may discuss PHI in front of a friend or family member if the patient has invited the individual into a consulting room to hear a physician's report. Having said that, if a patient is in an area where multiple visitors may be present and the identity of those visitors is unknown, refrain from discussing PHI until the patient is alone with his or her representative present. If the patient is unconscious or lacks mental capacity to consent, we may also disclose the patient's PHI to a family member or friend based upon the professional judgment that such disclosure is in the patient's best interest. For example, suppose an individual with an Alzheimer's diagnosis is brought in for a cataract evaluation. We know this patient is intermittently nonverbal. Would it be appropriate to discuss a proposed surgery with the patient's caregiver? Yes, absolutely. The patient would lack the ability to understand the aftercare for the surgery, so it is appropriate to discuss postoperative instructions with the caregiver. It is also advisable to document the patient's mental status, to whom the information was given in lieu of the patient, and the relationship of that individual to the patient. Patient authorization is not required when releasing PHI to many governmental entities for various purposes, including releasing information to the Public Health Department, disclosing information related to a workers' compensation claim, or releasing information to a jailer for patients in police custody. Because other types of governmental instruments, like subpoenas, may require additional support before PHI is released, please confer with a compliance officer prior to releasing PHI under the above circumstances. When asked for PHI for reasons other than those discussed above, an authorization for release of information signed by the patient or patient's representative is required. The authorization must be as narrowly crafted as possible and include the specific diagnosis and date range applicable to the PHI to be released. The authorization must also contain an effective date range, after the expiration of which the authorization is no longer valid. Certain types of PHI or other types of disclosures have additional requirements. For example, psychotherapy notes may only be released upon the documented approval of the authoring physician. When engaging in ongoing marketing activities, fundraising, or activities that involve the sale of PHI, additional permissions from the patient or the patient's representative must be obtained prior to the use of the PHI. Before disclosing PHI to anyone, make sure you know the identity of the requester. If the patient or patient's representative, elicit 2 unique patient identifiers to ensure you have the right patient's information. For example, you could have 2 Betty Smiths, so in order to distinguish between the 2, ask for Betty's social security number or her date of birth. Then verify the identity of the requester by viewing a government-issued identification, such as a driver's license or passport. Should you be asked to produce documents for a governmental official, first check the badge or identity papers of the official prior to producing the documentation. Should law enforcement present without a judicial subpoena and request information, please direct those requests to the compliance officer immediately. The minimum necessary standard is a HIPAA principle we should all understand. The minimum necessary standard simply states that covered entities cannot use or disclose more PHI than is reasonably necessary for an intended purpose. This standard applies to all SEAS Group staff. The only exceptions to whom this principle does not apply are the patient him or herself, the actual provider rendering treatment, or any other individuals authorized by the patient to have unlimited access to the patient's PHI. In practice, note the example on the slide above. A medical biller would have no reason to view images for a patient, as that information is not required for the biller to do his job. Remember to only access the minimum amount of PHI necessary to fulfill your job role. Remember that HIPAA recognizes the personal representatives of patients as if they are the patient himself. Thus, personal representatives have the right to exercise any rights the patient could exercise under HIPAA. Personal representatives are persons with authority under state law to act on behalf of the patient. You may hear them called powers of attorney, healthcare agents, or designated patient surrogates. When you hear these terms, please request a copy of the documentation appointing the individual as the patient's personal representative. That documentation should be maintained in the patient's medical record. The identity of the personal representative would also be verified by use of a government-issued ID. Minors also have personal representatives, typically their parents, guardians, or court-appointed foster parents. In some circumstances, a minor may also serve as his or her own personal representative. The following circumstances are examples of when that is possible. The minor is either married or has been emancipated by court order. If the latter, please obtain a copy of the emancipation order and place it in the minor's medical record. In some instances, parents may allow a minor to have a confidential relationship with a healthcare provider. Such arrangements should be well documented in the medical record. Lastly, providers may also use their professional judgment to determine that disclosing PHI to a personal representative is inadvisable. In each of these three scenarios, providers may opt to disclose PHI to the minor or someone other than the minor's personal representative. For instance, if a provider suspects the patient is the object of abuse or neglect, the provider may opt not to disclose PHI to that personal representative and may call authorities instead. This decision and the reasoning behind it must be well documented in the medical record. Reports of suspected abuse or neglect should occur promptly and should always be well documented. Now that we have learned about how the HIPAA privacy rule applies to covered entities, let's discuss how the privacy rule impacts the business associate of that covered entity. What is a business associate? It is simply a person or organization that is performing services on behalf of the covered entity and who has access to PHI due to the services being performed. Business associates must also take measures to comply with the HIPAA privacy rule. It is very important that we are correctly identifying organizations who may be performing a service on our behalf and must handle PHI as part of that service. We should have a written underlying agreement for each business associate as well as a signed business associate agreement. Above, you will see examples of people or organizations who are business associates shown on the left. That includes many people or companies you may encounter on a daily basis. Think about the outside collection agency our company uses, or even our attorneys or external auditors. All of those individuals or companies are business associates according to the definition found in the HIPAA privacy rule and on the previous slide. However, not everyone with whom we do business is a business associate. There are exceptions to the business associate definition, including providers who are involved in direct patient care, insurance companies, and general service providers such as janitorial or extermination services that have no reason to use protected health information in the delivery of their services. If you have any questions in determining if a person or company is or is not a business associate, please contact the compliance officer. Now that we have completed an overview of the HIPAA privacy rule, we understand that patients have certain rights under HIPAA. This includes a right to receive a copy of our Notice of Privacy Practices, the right to receive a copy of their health record in electronic format, the right to request an amendment to their medical record, the right to receive an accounting of disclosure or list of who has received information from their medical record, as well as when and why, a right to request restrictions on the way their PHI is used and shared, a method to authorize confidential communication of their PHI to others, a right to receive a notice about unsecured PHI or a breach of privacy, and a right to file a HIPAA complaint. In addition to individual rights under HIPAA, it's also important to remember the minimum necessary principle, appropriate uses and disclosure of PHI, when a patient authorization is necessary to release PHI and when it isn't, and how to determine if another organization is a business associate or not. Also remember that a deceased individual retains his or her HIPAA privacy rights for 50 years after he or she dies. Now that we have a grasp of the HIPAA privacy rule, let's learn about the HIPAA security rule. The purpose of the HIPAA security rule is to define how we may keep electronic PHI or ePHI safe. When maintaining the safety of ePHI, remember the three key principles of confidentiality, integrity, and availability. Confidentiality means that PHI will not be disclosed to people unauthorized to receive or view that PHI. Integrity means that the PHI is complete and accurate and has not been subject to alteration or destruction. Availability means that PHI can be accessed by an individual with a valid reason for accessing the PHI while remaining safe from unauthorized access. The HIPAA security rule requires that covered entities maintain ePHI in such a way that each of these three principles is satisfied. In order to protect ePHI, covered entities must establish safeguards. Safeguards are the actions we take to keep ePHI secure. There are three types of safeguards: administrative, technical, and physical safeguards. The goal of all types of safeguards is to protect PHI from accidental or unauthorized use, limit accidental disclosures, and include tools like encryption or even simple door locks. Technical safeguards are very important in protecting the networks that house the protected health information of our patients from malicious software. Antivirus software is an effective tool in detecting the presence of different types of malicious software, such as viruses, worms, or ransomware. Users should also be very careful to avoid exposure to ransomware or other malicious software by not opening attachments or clicking links within emails sent from unknown parties. Remember to also use safe internet browsing. Only use internet sites that are known to you to be safe and work appropriate. Another tactic employed by hackers is the use of spam email. Remember that spam email is literally unsolicited email. Spam can be very dangerous when it's used in phishing operations to lure users into sharing sensitive information like social security numbers, credit card numbers, or bank account numbers. Remember that the C's group will never ask you to disclose sensitive information via email. Should you receive an email that doesn't appear legitimate, notify Information Technology immediately. Remember that the HIPAA security rule requires the employees of covered entities to take reasonable steps to ensure ePHI that is shared via email remains secure while in transmission. The only surefire way to do that is to encrypt emails that are sent outside the C's group network when they contain PHI. Encryption is easy. Just type the word secure in brackets within the subject line of the email you are sending. As a recap, remember not to open emails or email attachments from unknown parties. When in doubt, throw it out. Don't reply to spam, simply delete it. Lastly, if you receive an email that appears to include a phishing element, report that email to Information Services as soon as possible. Because almost everyone owns a mobile phone, laptop, or iPad these days, and many of us use those mobile devices to conduct business, it's very important that we take precautions to keep the information on our devices safe. Start by having a strong power-on passcode that is required to unlock your device, and make sure only you know that passcode. Ensure that the controls on your device allow for automatic log-off or locking after a period of inactivity. If you are using a mobile device to access PHI, remember to have that device encrypted by Information Services. Lastly, don't forget to log your device onto the C's group network periodically so that antivirus software is kept up to date. Should your mobile device be lost or stolen, report the lost or stolen item immediately to Information Services or to the compliance officer. Remember that if the device is encrypted, loss of PHI and other confidential information will not occur, saving our company lots of time and money by avoiding a HIPAA breach. Now that we have talked about spam, phishing, ransomware, and even lost mobile devices, let's talk about some of the ways violation of the HIPAA security rule can occur within our own organization. The first type of HIPAA security violation to think about is probably more common than we know. That is a lack of control over your username and password. Our company maintains a password policy that requires a strong password of at least 10 characters, made up of a combination of letters, numbers, and special characters. Passwords must be changed every 90 days. Remember, it is a violation of C's Group policy to share your password with anyone. Violation of this policy is subject to disciplinary action. If you share your password with someone and that individual then uses your password to access the electronic medical record, you are still responsible for any actions taken by that person within the EMR, whether good, bad, or ugly, if those actions are performed using your logged-in credential. If you work remotely and use a mobile device such as a laptop, iPad, or similar device, you must ensure that such devices are in continual compliance with C's HIPAA security policies to maintain the safety of our networks and our patients' protected health information. Make use of company VPNs and transmit PHI only to locations within the C's secure network. Otherwise, encrypt all PHI going to outside networks. Ensure all Windows updates and antivirus updates are performed in a timely manner. Keeping our patients' protected health information safe and confidential is our responsibility as C's Group team members. Don't store PHI on mobile phones or other mobile devices. Use encryption when emailing PHI outside the C's Group secure network. Only access PHI when you need it to perform your job function. Always keep your password confidential and notify your supervisor promptly if you lose a laptop or other mobile device that may contain PHI. Remember that PHI on paper is still vulnerable. When you are ready to dispose of paper containing PHI, use shredding bins designated for that purpose. When you need to dispose of a hard drive or other magnetic media, that destruction must be done with specifically approved procedures. Contact the IT department by placing a help desk ticket, and you will be contacted with further instructions for how to dispose of your media. Let's talk about physical safeguards that we can use to maintain the security of our patients' PHI. Those safeguards might include placing computer screens in locations that cannot be accessed or viewed by people passing by who have no reason to view the data. Computers should use time-sensitive, password-protected screensavers. Servers must remain in secure areas where physical access is controlled by locks or other appropriate mechanisms. When HIPAA security policies are not followed, HIPAA breaches are more likely to occur. Remember that if you are aware of a HIPAA breach, you must report that information to the compliance officer. C's Group must then take steps to notify the patient of the breach of his or her PHI and notify the U.S. Department of Health and Human Services at least annually, and in some cases immediately when those breaches occur. HIPAA violations do have consequences. As of 2013, covered entities are required to enforce sanctions or disciplinary action when employees are found to have violated policies in place to comply with a HIPAA privacy or security rule. In addition to disciplinary action, individuals who violate HIPAA may also be subject to civil or criminal penalties imposed by the federal government, depending upon the type and severity of the violation. Remaining compliant with HIPAA is actually not that hard. By following some straightforward do's and don'ts, HIPAA violations can be prevented and HIPAA breaches avoided. Keep sign-on credentials private. Dispose of paper PHI properly. Hold discussions involving PHI in private. Encrypt emails that contain PHI or other confidential information. By holding to the simple list of best practices, C's Group will successfully avoid HIPAA breaches and avoid spending time and money that could be better spent elsewhere. We appreciate your help in helping us comply with the HIPAA privacy and security rules.